We are going to continue our conference with the presentation of Professor Katarina Smigova, Dean of the Faculty of Law at the Pan-European University in Slovakia. The title of Professor Smigova's presentation is The Right to Privacy and Freedom of Speech in Digital Era in Relation to Public Figures.
Good afternoon, ladies and gentlemen, all distinguished guests. It is an honor and a real pleasure to be here with all of you, with the research group members, with professors, Professor Wiels especially, and also with the PhD students, and I'll explain why while during the, 15th slide. The right to privacy in the digital age is a very, very challenging and inspiring topic because of several reasons. As for the specific terms, now during the break, I said that at the beginning of the project this year, I wanted to choose another topic for the article. Then I chose another one, and if it was now to choose the topic for a specific article, of course, I would choose another one because there's still something going on online, not only in Slovakia, but also especially in Slovakia. Although being a very small country, because of online world, the physical one seems to be smaller than it really is. Finally, the topic that I've chosen for the article is the right to privacy and freedom of expression in digital era in relation to public figures. There are many databases, there are many comments, many articles in relation to this topic. That's why I've chosen to focus on Strasbourg and Slovak Constitutional Court case law. And the reason why I've chosen finally this topic is the fact that there is a very hot issue in Slovakia that regards also Constitutional Court decision, but also other courts. And it includes the looking for balance in relation to the right to privacy of our head of state and freedom of expression of our member of parliament. Last time when we met, like this composition, I finished my presentation by saying that protection offline is comparable as for legal basis to protection online. That the fact that there is digital world, it doesn't mean that the protection itself, the aim is different. And it is the same for looking for the balance. And if we do research of the right to privacy and freedom of expression. First, as for today's presentation, I'll have some part focusing on right to privacy, then especially in digital era, especially in relation to public figures, and then freedom of expression, again, in digital era, and especially in relation to public figures. And the final part of my today's presentation will be given to the case that I've already mentioned. So, right to privacy. We all know, because of the last conference as well, that there is no generally accepted, in legal terms, definition of privacy. Nevertheless, it is included, the right to privacy, in almost all the national and international documents. As for my today's presentation and also as for the article, I refer to the right to privacy as a fact that individuals have their personal autonomy and identity, which deserves protection from outside interference, and this protection in legal terms should be provided by state. When we talk about digital era, of course, it is not only about physical world, but also about your name, your honor, and data, even metadata. But I'm not going to cover this topic nowadays. I'll focus on honor and name that is threatened much more intensively within digital world. Because as if the digital world had different time, different space, different type of control, also because sometimes people think that they cannot be traced back. their behavior online as if it was not traceable back to their conduct. And that's not true. Nevertheless, the way how we approach digital world, what we do there, what we intentionally sometimes do there, is influenced by the fact how we see the digital world working. Nevertheless, despite all those different aspects, the fact that when you put something online, you can see it, you put it there in Slovakia, you can see it in Australia within a second, what previously took much more time to get from one place to another. And it has already been mentioned today, as for the control, when you put something online, of course, theoretically, you've got the right to be forgotten. Nevertheless, technically speaking, forget about the right to be forgotten. And as for anonymity, well, it might be a problem it is not a problem to find the IP address, it is a problem to find the person who was sitting there at the particular time. Nevertheless, the issue of anonymity is not the subject of my presentation today either. So let's move to the case law that I've mentioned that I would focus on today. Right to privacy in digital era in relation to public figures. I've got good or bad luck now that Professor Koltai has already explained the von Hanover number 2 factual basis. What I would like to focus on or to stress especially is the fact that even public figures, even elected public figures, that was not the case here, have legitimate expectation that his or her private life is protected. And it was clearly said so already 10 years ago. What is different if we consider right to privacy in digital era is the fact that 20 years ago, there might be a problem to get to information. Nowadays, you have much more information that you are able to process. Therefore, it is very important to be able to select the information that you trust. And what is even more important, that sometimes is provided and given online, not seriously. Therefore, in the case law of the European Court of Human Rights, there are several concepts that have already been elaborated. The first one is the issue of seriousness. It means that not everything that you find online is provided there with a serious intent to be published and forward further. That was especially elaborated in the British case Tamis. And second, there is a so-called reasonable reader concept. It is actually the same point of view, or the same subject that is the concept that is elaborated within the court case law. Nevertheless, from the point of view of the reader, it means the Portuguese case that what do you expect the reader to do with the information? Do you take it seriously? How much of the information that you find online do you take, you personally, do you take it seriously? I'm not talking now about scientific articles, about reviews. I'm not talking about proved information from academic resources. I'm talking about all the information that is given online and that you read sometimes, that you only, by chance, get into your mind by looking at the title. So these are two concepts that have been already elaborated in the Strasbourg case law. And especially in relation to public figures, then there's another issue that has already been discussed. And it is the fact that even if you don't take all the information seriously, even if you think about reasonable reader concept, there are some issues that are not acceptable, not even to public figures, not even to elected public figures. And that is the issue of toleration, of being publicly accused of violent criminal acts without such statements being supported by facts. And that's very important Iceland case that was decided by Strasbourg. So that was the part of the right to privacy. Now, moving to the part of freedom of expression. If you aim to compare the importance of rights, right to privacy and right to freedom of expression, there is always human dignity and person involved. These are human rights, fundamental rights. And there is also, in both of these rights, personal development included. Nevertheless, while the freedom of expression is protected, there is also society development factor included. It means that, as we all know, freedom of expression, especially by media, is important because of democracy protection. Freedom of expression, as for the convention, is very special. I've included some specific information within the presentation because there are also duties and obligations within text included. And what will be stressed later as well, all types of information, even if you don't like the information, and any form of providing information is protected by the convention. Nevertheless, there is one very important article within the convention, and that's Article 17. Sometimes, if you think that you realize your freedom of expression, there might be a question whether you don't abuse the right that you are given as a human being. And it is especially freedom of expression within Article 10 protection that is then as a balance with Article 17, and especially freedom of expression has sometimes already been discussed and decided by the court that this has been an example of abuse of rights. Nevertheless, from the time being, the court in Strasbourg focuses much more, as for Article 10 protection, on the limitation clause than on the abuse of rights clause. You already know that as for paragraph 2 of Article 10, there are 5 steps to be checked by Strasbourg: the issue of interference, the scope of the right protected, the issue of legality, whether the act has been in accordance with law, the issue of legitimate aim, that is not so much controversial, and the most important step, the proportionality. It is elaborated within the article. I'm not going to discuss it in details now. As soon as it is published, I'll be happy if you read the article. Apart from this limitation clause, the usual way how the court decides or analyzes the interference is the issue or the methodology of what has been said about who and by whom, sometimes even when and how. But these 3 steps are being very often elaborated. So what online, offline, it doesn't matter. There's the basic distinction. It is that whether you provide information, facts, or opinions, valid judgments. Nevertheless, despite this original division of the types of information that is provided, it has already been confirmed, and I've chosen Feldek because it's Slovak case, that valid judgment may be excessive if there is no factual basis to support it. And I've chosen it because of the current hot issue case that includes our head of state. It is true, as has been very famously said in Lingen's Austrian case, the limits of acceptable criticisms are accordingly wider as regards a politician as such than as regards a private individual. Unlike the latter, the former inevitably and knowingly lays himself open to close scrutiny of his every word and deed by both journalists and the public at large, and he must consequently display a greater degree of tolerance. This is quite an old case. So afterwards, there have been many questions. And is there or is there not any limit for that greater degree of tolerance? I'll elaborate it especially in relation to the Slovak case. Now, about who? Originally, in Slovakia, there have been several even constitutional court cases when the honor of public figures, especially elected public figures, was put on such a high level that as if no criticism was allowed. And of course, it got to Strasbourg, and Strasbourg said, sorry, not acceptable. Freedom of expression has to be, of course, there has to be a balance, but you cannot say in general that elected public figures are protected and there cannot be any criticism. So Slovak Constitutional Court got clear no from Strasbourg, and I've included into my article also case law concerning France, because there was a special legal act protecting head of state, and the cases are called Colombani and Eon. These cases were tried to, supported by arguments from the part of France, by the fact that interstate relations are very important, and that defamation of a head of state might influence the interstate relations as well. It is not only about the person, it is about the state. Nevertheless, the legal act especially included also criminal offences punishment afterwards, so it was not acceptable for Strasbourg, and Strasbourg said you cannot criminally hold responsible somebody for criticizing head of state. So there was clear no from Strasbourg as well. And of course, I presume that all people from Poland know the Sanotsky case, where the issue about distinguishing person who holds a function within a state is very important, because it is not only about the function as such, it is about the trust of the public, how the function is exercised. And if there are statements that underdig your reputation, then you lose, especially online, the trust of the public very easily. So, of course, the public interest about dissemination of information is very important. Nevertheless, the balance has to be found in every single case, because, especially as for digital world, public opinion is not a professional just opinion, firmly distinguishing between facts and value judgments. Reasonable reader of online comment is not professional judge distinguishing what it is about, and that is different online, but it is the same offline. If there is something published, who decides what it is if it does not get to a court? And the third subchapter, by whom? Of course, Kastel's case, especially opposition members must be protecting, their freedom of expression, because protection of freedom of expression is protection of democracy. And I said during the break that I would be so, where is Dusan? You were right. Okay, because that helps a lot, the digital world, because your communication towards voters is much more effective. There is bigger engagement of citizens. They are not only passive recipients. So, Slovak case study. There have been 3 decisions. All 3 are upon interim measures, not on the merits. It is not about the freedom to hold opinion, but to impart information and ideas. The district court, regional court, and constitutional court And what was first the who, as I've already mentioned, just to make it short, our opposition member of the parliament who is very active online. He used to have his Facebook and he provided stages there with followers of almost 200,000. So for Slovakia, with 5 million people, that's quite a lot. Against whom? Head of state, our Slovak president. And what has actually happened? It started at the end of last year when a bilateral treaty between Slovakia and US was being negotiated. And the second phase started then after Russian invasion. I would like to thank PhD student. I had a presentation lecture last week because I translated some of the statutes and I realized that only the translation into English as if softened the way how it might be perceived by others. So what was offending in Slovak actually did not sound so in English, and I really loved your comment when you said, well, it's quite normal in Poland, which is like, all right. So I thought about what to focus on today. So thank you very much. And what I would like to point out is the fact that it is not, of course, about the language, because even offensive language is protected by Article 10. Nevertheless, what the court, all of them, focused, the first two, focused on was the fact that what is the aim of those statutes. And it was to evoke and incite strong negative emotions, and rational argumentation was largely absent. What the member of parliament said, I've chosen two statutes, he actually accused the president of particularly serious crimes like treason. That's the only crime that the president might be held responsible for in Slovakia. And the defendant efforts were to evoke strong negative emotions. There's the quotation. Because of lack of time, I'm not going to read it all. But the court said that that was the reason why to give the interim measures decision, because there was the imminent danger of threat for president. That was later proved also by the within the consequences, because people started to come in front of her personal house to threaten her there. And even there was, during one public celebration, 1st May celebration, where there were many people, and the member of parliament really incited the crowd to act. So that was not possible to be protected anymore, just to make it short. And exaggerated vocabulary and provoking expressions were not decisive. Systematic, long-term and focused verbal and hate-inciting attacks are not protected by the freedom of expression. Offline, online, doesn't matter. Even though public figures are expected to endure a higher level of criticism because of importance of public interest, they are not obliged to endure speech that might be considered rather abuse of right than exercise of the freedom of expression. So my question was whether, if that case got to Strasbourg, what the decision of Strasbourg would have been. So I think that the Strasbourg would have agreed with the decision of the courts. Thank you very much. If there are any questions or comments, I'll be happy to answer and listen to them. Thank you.